Good afternoon, my name's Lisa Henty and I'm a solicitor at Beale & Company, and my webinar today is giving you an overview of the Insurance Act 2015. At present, insurance contract law in the UK is based on principles developed in the 18th and 19th centuries. These principles were codified in the Marine Insurance Act 1906. The 1906 Act applied to both marine and non-marine insurance law. It is insurer-focused and was designed to protect the insurance industry against exploitation. 100 years on, the law does not reflect the modern world and the ways in which people communicate, store and analyse information. The Law Commission therefore decided to update the existing law by removing outdated and onerous rules and replacing them with ones which are broadly neutral between insured and insurer. The initial focus was on the consumer's duty to disclose information to the insurer. On the 6th of April 2013, the Consumer Insurance Disclosure and Representations Act 2012 came into force. This Act simplifies existing law and replaces the consumer's duty of disclosure with a new duty to take reasonable care when answering an insurer's questions. Following the successful implementation of the Consumer Insurance Act 2012, the Law Commission shifted its focus to non-consumer insurance contracts, and the draft insurance bill was introduced into Parliament in July 2014. Following much consultation, the insurance bill finally received royal assent on the 12th of February 2015. The law will come into force by the autumn of 2016. The provisions will only apply to policies entered into or renewed after that date. This period was expressly set aside to give the market time to make the necessary changes to its policies and procedures. The Insurance Act will lead to reform in areas such as disclosure in business insurance, warranties and remedies for fraudulent claims. The Act targets the following areas: duty of disclosure, warranties, fraudulent claims, contracting out, and third parties' rights against insurers Act 2010. Earlier editions of the insurance bill included a clause providing for damages for late payment of claims. This clause was dropped as, due to a lack of consensual support across the market, it was deemed unsuitable for the Law Commission's uncontroversial bill procedure. Duty of disclosure. I'm just going to outline the problems with the current law. The duty of disclosure in insurance law historically imposed a heavy duty on insureds to disclose all information that would be material to an insurer, even if the insurer did not ask for it. The onerous requirement to disclose to the insurer every material circumstance which the insured knows or ought to know before concluding the contract of insurance was a basis for change by the Law Commission, as at present it allows for an insurer to void all its obligations under the policy if that duty is breached. This includes innocent breaches by the insured. The Law Commission's report, which was placed before Parliament, identified problems with the existing duty of disclosure. Duty is considered to be too poorly understood, which results in the insureds making errors which can result in issues regarding coverage. The duty is considered too onerous, particularly on medium and large companies who are uncertain as to what is and isn't relevant. No provision to set out the manner in which disclosure is made. This leads to a large amount of undigested information being provided to the insurer for review, also known as data dumping. Also, the single remedy of avoidance is considered to be too harsh. The duty of disclosure has therefore been addressed in the Insurance Act for business insureds. The aim is to allow for a more neutral balance between insurer and an insured. The Insurance Act replaces the duty of disclosure with an obligation to make a fair presentation of the risk. This entails either the disclosure of every material circumstance which the insured knows or ought to know, or failing that, disclosure which gives the insurer sufficient information to put a prudent insurer on notice that they need to make further inquiries. The second limb is intended to operate where the insured has failed to satisfy the first limb, disclosing every material circumstance it knows or ought to know, but nevertheless has disclosed sufficient information to put the insurer on notice that it needs to seek further information from the insured before writing the risk. This is intended to combat the perceived risk of an insurer taking a passive role in the disclosure process and only asking questions when the insured makes a claim under the policy. The fair presentation of risk also requires the insured to make the disclosure in a manner which would be reasonably clear and accessible to a prudent insurer. It is hoped that this will discourage data dumping. The level of knowledge required of both an insurer and an insured is clarified in the Act to avoid any confusion. For the insured, if this is an individual, knowledge is not limited to his or her own knowledge, but it deemed to include anything known by a person who is responsible for the insured's insurance. This can include the individual's insurance broker. If it is an organisation, relevant knowledge is anyone who is part of the insured's senior management and those responsible for the insured's insurance. Senior management is defined as any individual who plays a significant role in the making of decisions of how the insured's activities are managed or organised. The explanatory notes state that senior management includes board members, but it can extend beyond that. Where the insured is a company, this reflects important decisions on the common law rules of attribution. The question is, what effect does this have on a composite policy? What the insured ought to know is defined by what would have been revealed by a reasonable search of the information available to the insured. Risk managers will need to ensure that systems are in place to ensure compliance. Knowledge of the insurer is dealt with under Section 5 of the Insurance Act. An insured is not required to disclose a circumstance if the insurer knows it. For this purpose, an insurer knows something if it is known to individuals who, on behalf of the insurer, decide whether they take the risk. In practice, this is the knowledge of the underwriters, although claims handlers can be involved. The insurer ought to know anything which an employee or agent of the insurer knows or ought reasonably to have passed on to the underwriter. For example, information held by the claims department or experts' reports commissioned for the purposes of assessing risk. This will include things which are common knowledge and information which is held by the insurer and is readily available to the individuals acting on behalf of the insurer. For example, information held in electronic records held by the insurer organisation. What is a material circumstance? This is dealt with under Section 7 of the Act. Examples of what might be considered a material circumstance include special or unusual facts relating to the risk, any particular concerns which led the insured to seek insurance cover for the risk, anything which those concerned with the class of insurance and fields of activity in question would generally understand as being something that should be dealt with in a fair presentation of risks of the type in question. Lastly, the duty of fair presentation includes the duty not to make representations. One of the biggest changes in the Insurance Act relates to remedies for breach of duty of disclosure. The Act aims to address the imbalance between the insurer and the insured. At present, the insurer is entitled to avoid a policy for breach of the insured's duty of disclosure. Under the Act, the insurer will still continue to have a remedy against the insured for breach of its duty of fair presentation. However, an insurer is required to demonstrate that but for the breach it would not have entered into the contract of insurance at all, or would have done so on different terms. Remedies are dealt with under Section 8 of the Act. Before the insurer can consider the remedy, it has to consider whether there has been a qualifying breach. Qualifying breach is defined as follows. If the breach is deliberate or reckless, the insurer retains the right to avoid the policy where it would not have entered the contract of insurance at all, or would only have done so on different terms. The onus is on the insurer to show that a qualifying breach was deliberate or reckless. If the breach was not deliberate or reckless, the remedies are proportionate to the impact of the breach on the underwriting decision. I've therefore set out a remedies for breach of duty of disclosure table, which is quite self-explanatory. Box 1 is quite simple. Has the breach been deliberate and or reckless? If the answer is yes, the contract may be avoided, no requirement to repay the premium. In relation to box 2, if the insurer would have entered into the contract but only at a higher premium, the insurer may reduce the amount to be paid on a claim proportionately. For example, if the insurer can show that it had known about the non-disclosed risk, it would have charged a premium of £400,000 instead of £300,000. Claims paid by the insurer could be reduced proportionately by 25%. In relation to box 3 and 4, and the point that would the insurer have entered into the contract on different terms? If the insurer shows that it would have entered into the contract but on different terms, the insurer may treat the policy as having included those different terms from the outset, if the insurer so requires. This could result in the addition of warranties or exclusions which affect the recoverability of claims. But the issue here is if the insurer decides not to take the point on the current claim, but decides at a later date it would have included different terms, does that amount to a waiver? Again, this is something for us to consider. Warranties have had an overhaul in the new Act. I've gone back to basics on warranties in order to get a full understanding of why there have been the necessary changes. An insurance warranty is a promise made by the policyholder to the insurer which, if broken, has harsh consequences. Section 33(3) of the 1906 Act states that a warranty must be exactly complied with whether material or not. Warranties are created in 3 ways: as either an express or implied term of the insurance contract, or through basis of contract clauses which convert representations into warranties. At present, a breach of warranty in an insurance policy discharges the insurer from further liability from the point of breach, even if remedied before any loss and even if the breach is unrelated to the loss. The courts have taken a strict view of warranties over the years, and the Act takes its lead from various judgments. An example of this is the case of Clare Knitwear. In this case, a doctrine known as a suspensive condition was adopted. The insured renewed its insurance covering its factory. During this term of insurance, the factory suffered from storm damage, and the insured sought to rely upon its insurance policy. However, within the policy there was a clause which required the factory sprinklers to be inspected within 30 days of renewal. The sprinkler system was not inspected until 60 days after renewal. Insurers sought to rely upon this as a breach of warranty due to another clause within the policy converting all sections of the policy to warranties. The court found that this was merely a suspensive condition as opposed to a warranty. It stated that whilst the insured was in breach of the condition, no cover was available. However, cover was restored once the breach was remedied. As such, there are 3 key changes. Firstly, the Act abolishes basis of contract clauses. They will no longer be valid and parties cannot contract out of this. Secondly, warranties will become suspensive conditions, meaning that a breach of warranty suspends cover until the breach is remedied. This means that a breach of warranty results in suspension rather than discharge of the insurer's liability, so that if the breach is remedied before the loss, then it has no impact on the insurance. Thirdly, in some instances, a breach of warranty will only prevent a claim if it increases the risk of the loss. This also applies to other terms in the policy. A new clause is now being included which applies to terms which reduce the risk of A. Loss of a particular kind, B. Loss at a particular location, or C. Loss at a particular time. An insurer will not be able to rely on non-compliance with the term if the insured shows that the non-compliance could not have increased the risk of loss. The change is consistent with the Law Commission's characterisation of warranties as risk control measures. If a loss occurs and a contractual term to which Clause 11 applies has not been complied with, an insurer cannot rely on that non-compliance to avoid or limit its liability for the loss if the insured shows that non-compliance could not have increased the risk of the loss which actually occurred in the circumstances in which it occurred. The easiest way to understand this point is by way of example. If a contract contains a warranty as to the maintenance of sprinkler systems, the warranty is breached and the property is burgled, the insured would almost certainly be able to demonstrate that sprinklers would not have prevented the burglary. The examples used in the explanatory notes is a requirement that certain types of locks be used on a window, and the loss is then caused by flooding. Failure to install the correct locks would not have increased the risk of loss of flooding. Of course, if there to a breach of warranty relating to the type of locks, but a burglar broke in when a window was left open, and even if it had nothing to do with the locks, the insurer should be able to rely on the warranty even though there is no causative link since it is the same type of loss. In order to limit the scope of the dispute, it would be advisable for insurers to specify in their policies what requirements they wish to impose, what risk of loss that requirement is intended to address, and what consequences non-compliance will have. It will be interesting to see how Clause 11 will have an effect on professional indemnity policies, which include condition precedents and claims conditions, as they have the effect of being caught under Section 11. It's one for us to consider further. Fraudulent claims has also had some changes made to it under the Insurance Act. The Act does not seek to define fraud, but instead sets out what an insurer may do in the event that an insured commits fraud with regard to a claim. The Act basically defines what has already been ongoing, but seeks to codify that. So when an insured commits a fraud against an insurer, the insurer is not liable to pay the claim to which the fraud relates. And if the insurer has already paid, it can recover the monies paid out when it subsequently discovers the fraud. In addition, insurers have another option, which is to give notice that the contract is terminated from the time of the fraudulent act, with no obligation to return the premium. This enables the insurer to refuse all liability in respect of a relevant event after the fraudulent act. A relevant event is specified as referring to whatever gives rise to the insurer's liability under the contract. Usually the loss or damage, but under some insurance contracts like professional indemnity, the notification of a claim. So if an insured makes a fraudulent claim for a theft of a necklace and subsequently suffers a genuine burglary, that burglary would not be covered if the insurer has adopted this course. The explanatory notes makes clear that fraudulent claim and fraudulent act are different, the fraudulent act being the behaviour that makes the claim fraudulent. Emphasis is also given to group insurance policies, whereby an individual may commit a fraud, but other members of the group policy have not. The fraudulent claimant and the insurer are treated as though they had entered into a separate contract of insurance between them, meaning that the innocent group members are not unfairly prejudiced. In relation to contracting out, the Act is intended to be a default regime for non-consumer insurance contracts. However, it is recognised that some provisions may not be suitable for all markets and commercial parties. The Act therefore allows the parties to non-consumer insurance contracts to contract out of the default regime. The only exception to this is in respect of basis of contract clauses which parties cannot opt out of. If, however, an insurer wishes to include a contractual term which puts the insured in a worse position than the Act would provide, then this must meet the transparency requirements, which are: the insurer must take sufficient steps to draw the disadvantageous term to the insured's attention before the contract is entered into or the variation agreed, and the disadvantageous term must be clear and unambiguous as to its effect. In determining whether the transparency requirements have been met, the characteristics of the insured and the circumstances of the transaction should be taken into account. For example, an insurer will have to do less to bring the provision to the attention of a large sophisticated company, which is advised by experienced lawyers and brokers, than it would for a sole trader buying off-the-shelf insurance online. Also, it will be sufficient to communicate just to the broker when he is acting as an agent of the insured. Some insurers, especially on bespoke business, may want to give serious consideration to contracting out from parts of the new law. It will be interesting to see how widespread contracting out becomes and how feasible it will be from a commercial as opposed to legal perspective. The main impetus behind the law reform was that insurance law in the United Kingdom was seen to be outmoded and not in keeping with modern commercial realities. Many brokers were saying that London was losing out as a result, since clients saw insurance law in other foreign jurisdictions as being more suited to their needs. Care will also need to be taken if an excess layer wants to contract out, but the primary layer does not. The Act also provides a valuable opportunity to correct problems identified in the Third Parties Rights Against Insurance Act 2010 in order for the Act to come into force. Very briefly, the amendments in the Insurance Act Part 6, Sections 19 and 20, add insolvency procedures through which an insured may qualify as a relevant person under the Act. It is hoped this amendment will allow the Act to be brought into force later this year. The comments, therefore, that we have seen so far on the Insurance Act are that the Act has been welcomed by many, as it is bringing commercial insurance law up to date and is deemed to be a tool to combat the perceived imbalance in the law in favour of insurers. Insurers, insureds and brokers will need to be prepared for the changes in the current law, from how a policy is sold and purchased to bringing and processing a claim, as well as if they make variations to the policy when it is in force. Underwriters are likely to face a number of challenges in adapting the new law, and they will need to make careful preparations as the Act will drive practical change in the way that business is placed and underwritten. Underwriters will need to be more proactive in searching during the underwriting process. Training for junior underwriters will be needed to make sure their knowledge is consistent with the requisite level. Insurers will also need to think about their underwriting guidelines and how best to document underwriting decisions in order to be able to take advantage of the remedies under the Act, especially given that they cannot rely on the draconian remedy of avoidance in relation to the insured's innocent non-disclosure. We will have to consider the policy implications when a potential claim may straddle 2 policy years pre and post the Insurance Act. How will the policies differ, and what will be the different outcomes for insurers and or the insured? Thank you for listening today. If you have any questions, please do let me know. I can be contacted on l.henty@beal-law.com and or 020 7469 0432. Thank you very much. Goodbye.